everyone. It's a great pleasure to welcome you to this, the fourth event in our series, Meet the Practitioners. And I'm delighted that we're going to be looking at the question of movement of EU nationals and British citizens and their status in the UK 1 year on from Brexit. I'm delighted that I have such an excellent panel. We're going to have a conversation between Kim Vowden, who is Senior Solicitor at Kingsley Napley. He has been involved in helping to resolve problems of EU nationals in the UK for at least the last 10 years. He is an excellent solicitor at Kingsley Napley, and he remains a firefighter as the problems arise in person. He is also one of the leads in the ILPA European Working Group. He's going to have a conversation with Michal Meduna, who is the European Commission expert on free movement of persons. Michal has been with the Commission for really quite a long time now, and I think I'm authorized to say that he actually negotiated the entry of the Czech Republic into the European Union from the perspective of free movement of persons. So he has dealt with the issues of a state which was a third country national, its citizens treated as a third country national in the EU, and how did they transition to become EU citizens. And now he's in charge of watching the 60 million odd British citizens transition into being third country nationals and no longer having rights. So a very wide perspective, and he speaks regularly with the British government on free movement of persons issues, but in particular on the treatment of EU nationals in the UK. I'm going to now hand over to Kim, who's going to kick off this conversation, and I'll re-enter every now and then when I can't resist the temptation to say something. So Kim, I'll hand over to you.
Thanks very much, Elspeth. And just to start off with, so as you can tell from Elspeth's introduction, Michal has quite an interesting role and quite a complicated one. So I thought, first of all, Michal, if you would like to just tell everyone, what exactly is it that you do and what have you been doing, just so we know exactly who you are and what your role is.
Thanks a lot, Kim, and thanks for having me and giving me this interesting opportunity to talk to you and to others. So as Elspeth said, I am working in the Commission for a long time. I actually joined in 2004. And I was given the job of monitoring the UK's transposition of EU free movement law. And I was really glad because, first of all, I speak English. I like French, so if I was given France, that would be a disaster. But UK was always the most interesting customer from the perspective of a case handler. UK was home to many EU citizens. So this meant that there were so many interesting life situations and so many interesting constellations coming out. UK also made no stupid mistakes. If the UK government or UK authorities made a mistake, typically it was a very well thought mistake. UK was always at the forefront of testing the limits of free movement law, trying to find where free movement law ends, where the European competence ends, and where there is a space for national rulemaking. And thanks to being in charge of the UK file, I also was involved in dealing with Mr. Cameron's reform demands back in 2016. And I was trying to find a solution to what the Commission actually promised to do, which was basically to undo the Mattock judgment and to allow member states to apply national rules for the first entry of non-EU family members of EU citizens. And I was also trying to find a way how we could review deportation thresholds, which is also which was also another thing the Commission promised to Mr. Cameron. Luckily, I was not forced to do anything out of it, because all those offers have been taken back after the referendum, where a different path of started. I was trying to prepare for the UK's withdrawal, and thanks to my experience, I was seconded in 2017 to Mr. Barnier's task force, and I was asked to help negotiate the citizens' rights part of what became the withdrawal agreement. So from 2017 to 2018, I did that. I was one of the negotiators for the European Union. I was particularly focusing on residents' rights and basically grandfathering EU free movement law and the EU free movement directive. I did my job in March 2018, where everything was concluded, and then I went back to preparing for the withdrawal. I was watching the drama of passing all the necessary in the UK government, in the UK Parliament, sorry. And I then rejoined the task force back in 2020 to prepare for the transition and to monitor the withdrawal agreements implementation and application, both in the United Kingdom and in 27 EU member states.
Great, thank you. Oh my gosh, it's very interesting to hear. You obviously have your perspective so different from a lot of us who are working sort of on the ground making application, you know, to the Home Office and so on. So to hear you say that the UK government, you know, any mistakes it makes are deliberate mistakes and carefully thought through, that's not always the impression that we get. Obviously, it's very different from where you see it. But no, that's fascinating. So perhaps you could tell us a bit about, so maybe just to sort of summarize the key steps that have been taken. So because some people might not be familiar with just the mechanics of it, and what you think were the key moments perhaps in this process and the key decisions that were made, and what you thought sort of drove them perhaps in this process to where we are now.
All right, thanks a lot, Kim. Well, my involvement in the negotiations started immediately after the referendum, when we launched our preparatory work. We need to establish our EU priorities. We were trying to find out what the UK position may be. We were wargaming different scenarios, and we were doing some basic preparedness, because some things were clear that those are going to happen one way or the other. As I said, I joined the Mr. Barnier task force to negotiate the residents' right, and I was really worried at that time, because all my previous experience with the UK authorities was not very positive. UK was the most rewarding customer, but they were also very difficult to negotiate and to really convince them to change the way how they work or change the rules. So I was really scared, but I was really surprised to see that somebody completely different turned out. It was not those Home Office people I knew. That was a completely new group of people who were really open-minded, who were really trying to find solutions, who were constructive, who were listening. So we were immediately off to a great start. That we basically the chemistry between us worked very well, and also thanks to that, all the talks progressed relatively quickly. The negotiations were concluded within half a year, essentially, on citizens' rights part. It helped that the negotiations were sequenced in a way that citizens' rights were among 3 issues which had to be concluded first, together with financial settlement and Northern Ireland. And this clearly helped to focus our minds. But we were working very well together. with our UK counterparts. We produced a joint progress report in December 2017. We were very transparent in the whole process of negotiations. We were publishing joint colored technical tables, which were showing how our positions evolve and how they converge. And we have always put a lot of emphasis on being transparent. So I think this is also useful for people who try to understand the withdrawal agreement and what happened. We of course had to find a solution to some of the UK's red lines, the demands basically they were making, and from the beginning they wanted some big changes to the way how EU law should work, or how the withdrawal agreement should carry over EU free movement law. First of all, they wanted to switch to a constitutive residence scheme, which is no longer rights-based, but more permission-based, which is of course a complete departure from the free movement directives.
So that's where people have to apply for a status and be granted it, rather
absolutely.
than have the right to automatic. Yeah.
Yes,
do they want
absolutely.
And do they want that for everyone, for all across both ways, that it had to be that design, or do they would just say we want to be able to do it like that if we want to? What was that?
No, they wanted to have a constitutive scheme. They outlined it already ahead of the negotiations in their position paper, and as I said, this is a huge revolution, because under EU free movement law, you don't need any papers. Basically, your resident status and your rights are conferred directly upon you by union law, and you have all the entitlements simply because of who you are and that you meet the conditions. But in a constitutive permission-based scheme, you need a paper. Essentially, you need an authorization, which then gives you the right. So there, the source of your rights is not EU law or you meeting the conditions, but it's actually you holding a residence document. And we had to find a solution to that. We also had to find accommodation for UK demands concerning deportations for criminality committed after the withdrawal. We also had to accommodate, or we decided to accommodate, the UK demands concerning systematic criminality and security checks at the application stage, which we believed were justified because of the switch from the constitutive, from the declaratory to a constitutive scheme. And we also had to deal with UK demands concerning the way how the residence scheme is going to work. They wanted to start as early as possible, because they were afraid that they're not going to be able to handle all the applications in time. And they wanted to switch to digital-only scheme, which is again something very new for EU law. And all our member states are still back in the analog era. So we were all watching very nervously what the UK is going to do with the digital-only scheme. In the negotiations, we were really helped by external stakeholders representing EU citizens and UK nationals, the 3 million representing EU citizens, and British Europe representing UK nationals. And their input and advocacy was remarkably important, and actually helped to deliver a better withdrawal agreement in the end. So after the negotiations were concluded in March, I was focusing more on producing sort of explanatory memorandum for citizens' rights part, which is a EU's document providing guidance and more interpretation. And at the end of the transition period, or towards the end of the transition period, we had a huge task ahead of us, and that was basically how to prepare for this sudden new difference in how we should treat UK nationals. Before, all UK nationals were treated in the same way as beneficiaries of the right of free movement, and suddenly we had two groups of UK nationals: one, beneficiaries of the withdrawal agreement with the right to reside in the EU and with some connected rights, and then we had all the newcomers, UK nationals, the rest who were not protected by the withdrawal agreement, but who were still carrying the same passport, who were not in possession of residence documents, because some of the beneficiaries didn't have residence documents at that time. So that was a huge practical challenge, and inevitably we had some challenges, and we had some problems, and some people have seen their rights negatively affected. But it went relatively smoothly, also thanks to the fact that basically everybody was prepared for things to go wrong. Everybody was prepared to react on the spot, take a very flexible and pragmatic approach. And I'm also responsible for the implementation of the withdrawal agreement, and there basically on the Commission side we have all the standard powers, tools, and enforcement measures that we always used to have. So I can take, say, Germany to the Court of Justice, not me, but I can suggest that Germany is taken to the Court of Justice for not implementing the withdrawal agreement correctly, and then the Court of Justice can rule and say, well, Germany has indeed violated their obligations under the withdrawal agreement. But I have no such powers to take the UK to the Court of Justice anymore. We of course have to go to arbitration, and that's why we were pushing really hard to establish some sort of European Commission that would be in the UK, an organization that would emulate our monitoring and enforcement powers. And we are really glad that we have the independent monitoring authority established and operational and based in Swansea that has such powers and has actually exercised them already, which is great news. Yeah.
Can I just take that one thing just before the implementation, just on the actual agreement itself, because it's interesting that it did seem to go pretty swiftly and signed out. And from the outside, it was very hard to know what the sticking points were. And you sort of outlined a few of the things. One thing that I remember was trumpeted quite a lot here was that the British saying, we've managed to negotiate this great thing that if you have permanent residence, you can stay outside for 5 years and you won't lose it under this. It was this great thing, and as if that was they sort of hard, won right. Was that a big thing? And was that? I take it that was the British idea. They did claim it, but that seemed to be the only thing that was that I remember being publicised as this is our great victory. What was that all about?
Yes, well, the withdrawal agreement has, although it is based on free movement law, it sometimes goes beyond free movement law to take into account the specific context of Brexit. And the most important sort of interference brought by Brexit is that you no longer can exercise your free movement right. In the past, if something happened to you, you exercised your right, you went to Sweden, it didn't work out, you had to come back. You still had the right to go to Sweden next year. You still had the right to go to Denmark. Yeah? But after Brexit, the withdrawal agreement protects only those a really closed group of citizens who were exercising their free movement rights at the end of the transition period. And once you are out of this group, you in principle cannot come back. So we had to make sure that the withdrawal agreement doesn't have sharp edges or hard edges, and that it makes sense a little bit more in this context where you cannot simply exercise your free movement right. And as you know, you can lose your rights if you are absent for too long from the territory of the host country. And And for the right of permanent residence, you can lose it after 2 years of continuous absence. And we agreed to prolong this to 5, to give more opportunity to people to move around the world without losing the unrecoverable status of the beneficiary of the withdrawal agreement.
So everyone was happy with that. Both sides thought that's a good idea, did they? That wasn't a particularly a great victory over the European Union. That it was both.
No.
Ah, okay, interesting. Yes. Okay, so it sounds like the withdrawal agreement itself, it was sort of quite a slick process, and both sides are reasonably content with an agreement. What about the implementation itself? So if we think about the implementation in the UK, so the EU settlement scheme is how it's implemented. Do you want to talk a little bit about just to explain the basics of how that works? I mean, on the surface, it is. You apply online and it's so on. Would you like to just give an overview of that first of all?
Absolutely, I would be delighted to. So the withdrawal agreement essentially builds on a shared objective of the EU and the UK ahead of the negotiations to protect exercised right of residence. Those who are already residing in the other country should be allowed to stay, and they should be allowed to stay under broadly the same conditions as before. So this was like the shared objective. So that's why the withdrawal agreement protects those EU citizens who have been exercising their treaty rights in the United Kingdom at the end of the transition period, which is 31st of December 2020, and who continue to do so afterwards. And the withdrawal agreement does not require EU citizens to be physically present in the UK on the last day of 2020. They simply need to have a right to reside, which is being exercised. So arriving on the last day is still perfectly fine, and those guys are beneficiaries of the withdrawal agreement. It was much easier to find a solution to EU citizens. It was more difficult to find for UK nationals. And for UK nationals, they again, as EU citizens, are able to stay in the host country in which they were exercising their free movement rights at the end of the transition period. But in principle, this is only one country. So UK nationals who were exercising the treaty rights in Spain can stay in Spain, but they cannot in 2022 decide, I want to move to Luxembourg. Of course they can, but they are no longer beneficiaries of the withdrawal agreement in Luxembourg. They are usual foreigners. So as EU citizens can stay in one country, namely the UK, so UK nationals can stay in one country, and that's the country where they were exercising their free movement rights. And again, the shared objective was to sort of replicate the effects of EU law and to carry it over as much as possible. And that's why you very often see in the withdrawal agreement references to EU law, that it continues to apply under the conditions of EU law. So EU law continues to be very important in the UK. And what is very important is that you have simply one status under the withdrawal agreement, and that's the withdrawal agreement beneficiary. And that's something where we have some disagreements with our UK colleagues. We believe that this one status only has dynamic rights, dynamically evolving rights, while the UK thinks that there is a succession of different statuses. But I guess we will come to this later when we are discussing problems related to pre-settled and settled status.
Well, can we do that? Should we just explain that now, just in case people aren't familiar?
Absolutely.
So basically, in the UK, so the way it works, so the UK is obviously the EU settlement scheme which we have doesn't quite replicate those EU law rights. It's sort of hammered into the UK's own immigration system, and you apply for permission to stay. Used to be what's called leave to remain, and if you apply for it, fine, that's allowed. The withdrawal agreement, it's a constitutive scheme like that. So basically, you apply, and if you've been in the UK, just physically present in the UK for 5 years before the end of the transition period, you're eligible for settled status. Less than 5 years, pre-settled status. And then once you've clocked up your 5 years, you apply to convert it from one status to the other. So like you said, they're two separate statuses. And I mean, it seems to me that there's all sorts of divergences from your law, but the key one is that you don't have to have been exercising a right of residence under EU law before the end of the transition period. Just a physical presence is enough. And I think that there's obviously very sort of practical reasons why there are millions of people who've applied for this, and it's very welcome. But what's your take on that gap there? The fact that there's no requirement to show that you were exercising a right of residence as a worker or a student or self-sufficient or whatever it is, that you just have to show physical presence. And how does that pan out from your perspective? That difference?
Yes. Although this is actually the oldest issue we have with the UK's implementation of the withdrawal agreement, and this has been discussing with various committees for second year already. The withdrawal agreement requires constitutive member states, or authorizes rather constitutive member states to oblige resident. I will talk only about the UK, but the same applies also for 13 constitutive EU member states. So under the constitutive scheme, UK can oblige resident EU citizens to register, to apply for a new resident status. And the purpose of this application procedure is that the UK authorities can verify that the conditions have been met, and then they have to evidence this by issuing a digital residence document. As I said earlier, the withdrawal agreement protects only those EU citizens who have been exercising their treaty rights in the UK at the end of the transition period and continue to do so afterwards. But the UK has decided already from the very beginning to waive the residence conditions. So this means that more EU citizens were allowed to stay, because inevitably there was a large number of EU citizens who were not meeting the conditions, whom the UK would be entitled to say, sorry, Mr. EU citizen, you don't exercise your treaty rights, please go home. The UK decided to be very generous, so allowed this group of people to stay, which we estimate to be around 400 to 500,000 people. But the downside of this was that actually nobody knows what their status is. Everybody, those EU citizens who actually met the conditions and those who did not meet those conditions, they have the same status, namely the status granted to them by the EU settlement scheme. And they don't know whether actually their rights are protected by the withdrawal agreement, which is clearly the case for those who met the conditions. And in that case, their rights are protected for their lifetime, or whether their rights are simply stemming from UK domestic legislation, which decided to waive the condition, and their rights are not granted for their lifetime, but only for the lifetime of the legislation which granted that. So there is a huge lack of legal certainty for everybody. EU citizens do not know, UK authorities do not know. If I pick a random EU citizen and ask the UK authorities, is this guy a beneficiary of the withdrawal agreement or not? They will not be able to say without further testing.
No, lots of people themselves won't know as well. They'll have no idea. Nobody knows. No one's tried to assess.
Nobody knows.
So, I mean, so far, we don't hear about any practical implications of that split. The fact that there are these two unnamed, unidentified groups of people. But what do you see as problems that can come from that potentially? Obviously, the fact that some people are protected by the withdrawal agreement, others, a number aren't. How do you think that's going to play out?
Well, I don't know how it is going to play out, but we are really concerned about the lack of legal certainty for beneficiaries of the withdrawal agreement. And as you said, for the time being, there seems to be no real consequences for you, whether you belong to the more protected or to the less protected group. But this can change. This can change in 15 years' time. The UK can decide to change their rules and treat those groups differently, and suddenly this change, which can never be excluded, because the UK Parliament can always decide to legislate and do it that way. That change would require the UK authorities to retest basically all EU citizens and to check what their status was at the end of the transition period. And something which was relatively easy to do before the end of the transition period might be still relatively okay to do now, will become progressively more and more challenging as time goes by, because you will be asked what you were doing in 2020. Like I would struggle to establish what I did 15 years ago. I don't keep the papers.
So maybe what they could have done, they could have been generous and say, we'll grant you this status, but as part of the process, that, for future reference, we need to know what you're actually doing at the moment, or what you were doing then, so that we can sort of put an asterisk next to your name as, oh yes, you're one of the, I don't know. But anyway, it's too late for that now, isn't it? Presumably that's not going to happen. So we're just going to have to wait and see. Wait in a few years, just the other hand. But Michal, can I also ask you about just the other thing which you mentioned, the fact that, that you view as well as you are protected. You have this status, you're protected. Now here we've got the pre-settled status, which once you've done 5 years, you convert to settled status. Obviously, that's a very controversial issue. And do you want to talk a bit about the Independent Monitoring Authority and the judicial review? Because obviously a lot of people are not very happy about this, and the fact that if you don't, because as it stands, if you're on pre-settled status, you've got your digital status, and it'd be quite easy to forget when that expires. And if you don't apply to convert it to settled status before it expires, then in the eyes of the UK law, you're an overstayer, and that's what the Home Office would say. It's but it's not as simple as that, is it? So what's your take on this?
Yes, well, first of all, those are, let's say, typical problems of transposition of EU law or the withdrawal agreement, notably in those 14 constitutive countries, because those constitutive countries, and the UK is like maybe the best example, they have their old constitutive schemes. They want to recycle, and they are trying to really put the withdrawal agreement into the definitions, into the philosophy, into the architecture of their constitutive scheme. It doesn't always fit, so you are trying to really squeeze it, maybe cut some parts. But that's the source of our never-ending problems in the transposition of free movement law. We have one free movement law to which all 28 national schemes have to adapt. It's not that free movement law has to adapt to all 28 different schemes. So that's always this struggle between the Commission saying, no, you have to change, you cannot continue using your old stuff, you have to come with new stuff. So here, I think UK is trying to recycle the old scheme and the old logic as much as possible, and we see this very well presented in this one immigration status only approach. You cannot hold multiple residence statuses. There has to be this one or that one. You have to choose. And we have a completely different approach. We believe again that there is one status, which is the status of the withdrawal agreement beneficiary, which you keep for as long as you meet the conditions. You cannot lose it for any formality. You cannot lose it because you have forgotten to apply to have something upgraded. And as you accumulate your right of residence, as you become more and more integrated into the host society, then automatically by operation of law, your pre-settled status should switch into a settled status, because you have already 5 years of residence. Yes, you might still hold a pre-settled residence document, but this doesn't take away from the fact that you already have a settled status in the eyes of the Commission. And then you can ask to have your residence document upgraded to align it with the underlying legal reality. The UK takes a different approach. You have one status, which is granted for 5 years, pre-settled. Within those 5 years, presumably you will accumulate the time needed for the upgrade to settled status, but you have to apply for that different status. That's a different status. You have to apply. If you don't apply, you are in trouble. Yes, your application might be accepted as a late application, might be considered by the UK authorities, but this is a completely like philosophical difference in view how the system should work. And that's why we are very glad that the Independent Monitoring Authority follows the same logic as the Commission and has launched judicial review proceedings before the High Court in mid-December last year.
Yeah, so that really is such a fundamental difference, isn't it? And is there anything else in the before we get onto the practicalities, in the actual framework, in the design of the EU settlement scheme that you have a view on, or you think isn't right, or is that it?
No, we have some concerns, but before I go into concerns, I wanted to stress that, like, we always had concerns, even when the UK was still a member. We have concerns about transposition and application everywhere. So this is a really complicated area of law. Yeah? Nobody really gets it right. Yeah? So we are not concerned that there are concerns. Actually, we expect there to be problems. Yeah.
Yeah.
So the UK, the concerns we see now in the UK are not, worse than it used to be. I would say it's better than it used to be. Yeah? But there are still concerns. Yeah? We have concerns about temporary protection, about how late applicants are treated. Yeah. Notably when it comes to sequencing of the decisions which are needed to decide on a late application. We are also concerned about retroactive application of a grant of the status. We have concerns about absences, how absences are calculated in the UK, and how they should affect the right of residence and the status. We are concerned about extended family members, or in principle about family members who are from outside the EU. We are concerned about how prison sentences impact status in the UK. And then we have this meta concern about UK's reliance on direct effect, where you rely on direct effect to basically implicitly set aside some parts of the legislation without saying which parts of the legislations are set aside.
Yes. No, that's right, isn't it? Because one thing, it's what we found is that it's quite sometimes difficult to know what's being done isn't what they say is being done. So you look at the law, it says one thing, practice is quite different, and sometimes the law isn't there, so it just seems, well, what actually is happening, and they're sort of applying a policy decision to do it definitely, and not very clearly. But okay, let's pick up on some of those things. So can I just, there's lots of negative stuff, but just we ought to talk about the things that are positive. So you say it's not, there's always been problems. Some of the good things about settlement scheme, one thing that is extraordinary is just the volume of applications that have been decided. Because before it was set up, we thought there are obviously millions and millions of people are going to apply to this, and how on earth will they cope? And they were so slow to process applications under EU law to issue documents. So this is people calculate it would take them 100 years to process them, and obviously that's why they've decided something which is on the surface, a very simple process. And at the start, it was very simple and very quick. And one thing that came as a huge surprise was these public statements saying that caseworkers will be looking for reasons to grant applications, which is just extraordinary to anyone who deals with immigration law here. I mean, usually there's reasons to refuse. Anything's wrong, it's refused. This is the other way around, and certainly, on the whole, it's difficult to sound like things to set up, but on the whole, at the start, it was very, very much like that. So that's a plus. And the other thing that was really striking, which was that there's this phone number that you can call, and obviously got to a few months ago, it was very difficult to get through, but for a long, long time, you could call someone, a human being would answer the phone, and they would genuinely try to sort out your problem. And that was something extraordinary. And we keep saying, can you just please do this in the rest of the immigration system, please? So those are some good things. But obviously that's great. But let's talk about the things that aren't so good. So one thing that's especially now, and I'm sure you hear about this a lot, is this very long delays. So there was the end of the transition period, then there's a grace period, so people could still apply up to the end of June. That was the sort of hard deadline, and so there was a rush of applications then, and they've managed to get through most of the simple ones that were done before then, but there are still people waiting months and months, and especially and for a long time it's been the case, anyone's got any kind of criminal conviction, even if it was way below the threshold for refusing application, would just go into a huge long queue. It's impossible to get it out. There's a particular problem now for people who which may not be quite such the thing that you're looking at, but for people who are making what's called surrender sing applications, so British citizens who've exercised a right of residence in the EU and are coming back with their family members, they're supposed to get back here, but with their family members, and their family members apply under EU law for pre-settled status by the 29th of March. But in many cases, to get here, they've got to get an EU settlement scheme family permit, and those are taking months and months and months to be issued. And so in the meantime, we've got some unofficial statements from the Home Office saying, oh, don't worry, as long as you've applied for your permit before the 29th of March, that's fine. But, well, you say that, but where's the, what's the law behind that? So there's those problems. And we also have this issue as well with people who've made applications and are traveling. And we do get lots of, and you probably hear these stories as well, people getting a lot of trouble at the border where they are sort of, I mean, I've noticed this myself, just traveling. If you travel on Eurostar, it's a different feeling. When you at Paris trying to, there's those border force officials are stopping people. So, what are you doing? You live in this country? Who says you live in this country? What's your status? Let's see it. It's and if people, I've applied to the asylum scheme, haven't got it yet. People are getting some pretty unpleasant responses, and sometimes getting some very weird things. So we'll give you temporary admission for a while, but you can't travel again. And that's a particular problem for people, for family members of non-EU family members, their country national family members. So that's what. One other thing, which was sort of goes back to what you said before, was the fact there aren't physical documents. So for EU citizens themselves, it's digital, and now the Home Office is rolling that out to other people because they clearly want to go this way. And there's been, people flagged up right at the start, this is a serious problem for a lot of people, especially people who aren't comfortable with technology and so on. What's your view on that, on the fact that this is really basically a digital thing, and people, most people aren't going to get documents? Is that just, well, that's how it is, or what's your take on that?
Yes, thanks a lot. I really wanted also to highlight all the successes in the UK. As you said, the volume of applications processed is mind-boggling, and I really like that you can lodge residence applications from your phone or from your computer. You don't have to travel anywhere. As you said, this new human approach to applications, where applicants are treated more as clients and customers, and all the grant-funded organizations the UK is supporting, and all the communication efforts. This was really great. And as you said, the UK authorities are very much engaging with us, with the delegation. So that's great. There are some problems, of course, and digital status is one of, I think, battlefields for the future, where we will continue to log horns with the UK. It's not that they have decided for a digital-only scheme. This is explicitly allowed by the withdrawal agreement. But digital scheme is basically being tested on EU citizens. Yeah, well, somebody had to be first, so I'm not going to whine. Digital status or digital scheme has certain advantages and disadvantages, and it's not all black and white. All physical residence document scheme or a physical visit to local police station has also advantages and disadvantages, and it always depends on how you manage those advantages and disadvantages. And with digital status, you overcome the biggest weakness of declaratory scheme, and that's you have a residence card, which might say that you have a right to reside, but if you no longer meet the conditions, the card is useless. With the digital status, everybody can be more confident that the status they see on the screen is actually the correct status. You don't have to carry the residence document with you. You cannot lose it. It cannot be stolen. But there are some disadvantages, especially for those who are vulnerable, who struggle with digital technology. And again, it depends on how this is being managed. We were following very closely the litigation done by the 3 million against the digital-only scheme. And I think that the way how the UK is going to react to this and the experience they are going to have with digital-only scheme will be decisive in determining whether actually what they are doing is lawful under UK rules or not. And but on the other hand, to be honest, like many countries are watching what the UK is doing, like this switch to digital only, switch to applications lodged by phone. That's, I think, also something we are going to do in the future. And everybody is watching the UK very keenly to see how they succeed.
Thanks. Elspeth, I'm just going to check in with you just to see how we're doing for time here, because there's a couple of things I'd like to ask a bit more, but how obviously we want to leave some time for questions.
Well, I think we have 3 very interesting questions. So can I suggest that we put the 3 questions, and then if we have time, we'll come back, because we will finish on time, and Gulsh will end the meeting. So the first question is from Bernard Ryan, and he wants to know whether you're able to say why own national sponsors, that is the Singh and Zambrano cases, were excluded. And it would also be interesting to know why Luna's cases were treated differently. The second is from Warren Simmons, and he asks whether you can give any views on how other EU member states are processing applications by UK nationals to equivalent schemes in their member state, and are there any problems that the UK can avoid from the experience in other member states? And then Nick Barnard provides a bit of a gloss, a further extension on Bernard's question. And he says that although we refer to the rights of citizens under the agreement, it seems to me that the outcome is far less constitutional than the language of citizenship suggests. It is not so much about the rights of citizens as such, about the rights of EU nationals in the UK and UK nationals in the EU. One issue that is left out in particular is the rights of citizens against their own member states. So this is back to the Zambrano Surinder Singh. Unlike the package of rights that union citizens have in EU law, which include rights against their own member states, was this a deliberate choice of both sides in the negotiations to completely exclude that aspect and adopt what one might call a more transactional approach of protecting our nationals against detrimental treatment by the other side, rather than aiming to protect the status quo and the rights acquis of union citizens on both sides caught up in the consequences of Brexit? Now that's quite a mouthful. Michael, what do you can pick and choose what you want to answer, and you've got about 5 minutes to do that in.
All right. Thanks a lot, Elspeth, and thanks a lot to those who asked the question. So, from my experience with free movement in the old times, Free movement was always controversial, but any extension of free movement to own nationals was even more controversial. And in principle, it is for member states to decide what the immigration rules are for their nationals and their family members. And member states were guarding this area of their own competence very jealously. And any incursion into that from EU law was always very, very difficult and contentious. So this is one of the reasons why I think Surinder Singh and Zambrano cases were not included. Also because EU was interested in protecting EU citizens in the UK, and UK was interested in protecting UK nationals residing in the EU, but not in the Surinder Singh or Zambrano case situation. And also there was not enough, how to say it correctly. we essentially had only 6 months to negotiate, and this would be a can of worms which would be very difficult to overcome. So from the very beginning, the positions of both parties were pretty much that we are going to look after our own citizens, and your own citizens are up to you. And that's why I think Lunes was treated differently, because that's somebody with dual nationality who is still who we still consider to be our guy as well. Yeah? And I think that was also the reasons why there is this transactional logic on what other member states are doing. First of all, we have 13 member states which operate a constitutive residence scheme, as the UK does, and we have 14 member states which operate a declaratory scheme, which basically carry on with what they have been doing so far. And 70% of UK nationals live in those declaratory member states. Only 30% live in the constitutive scheme, and the experience from declaratory schemes is often not so relevant for the UK. But we also have to recall that on average, an EU member state has 40,000 UK nationals residing, and 40,000 is peanuts. Like, this was a couple of days of applications worth at the peak. Yeah. And those member states had years to deal with those people. So the amount of challenge is completely different. Member states also made choices which were fine at the moment when choices were made, like to continue with a physical residence document, to continue with the biometric residence documents, to continue with physical appointments where people come, they lodge their applications are processed, residence documents issued, you have to come, you have to pick it up. All this was very much disrupted by COVID, which impacted this administrative capability. So I think in retrospect, many member states wish they had a more digital scheme. They were trying to introduce some elements into it. Otherwise, I don't think that there is a lot what can be sort of learned from member states. What member states and the UK were doing very well was to cooperate when it comes to awareness raising and communication campaigns, and to see what the other guys are doing to get an inspiration. But also it was a nice to learn that all those awareness raising campaigns worked best when both the UK and the host state cooperated together, whether it was in the UK or whether it was in Estonia or Poland. So this also shows this sort of continued trend of the UK and the EU working together for the benefit of EU citizens. And I hope that this is going to continue for next years.
Thank you very much, Kim and Michal. It was a wonderful session. I've learned a lot. You have made it very lively in the way in which you presented it. And I concur entirely with Bernard. It was tremendously informative. Thank you so much for participating and sharing your knowledge and experience with us. And thank you also to all of our audience who's come and listened to us, and to those of you who have asked some really good questions as well. And don't forget, we have one last session in this series, Meet the Practitioners, on the 24th of February on whether the UK asylum procedures make women asylum seekers vulnerable. So we'll see you then. Thank you very much. Goodbye, everyone.
Goodbye.
Bye-bye.